Quo warranto is thus a very powerful instrument for safeguarding against the usurpation of public offices. Parliament power to modify or restrict fundamental right. Parliament power to modify or restrict fundamental right. The limitation upon the enforcement of fundamental rights are as follows. Parliament shall have the power to modify the application of fundamental rights to the members of armed forces, police forces, or intelligence organization, so on ensure proper discharge of their duties and maintenance of discipline among them. Article 33. In exercise of this power, Parliament is enacted the Army and Air Force Act in 1950 and the Navy Act 1957, which empower the central government to make rules restriction the fundamental rights of the defense personnel for the sake of discipline, which is absolutely essential to maintain in security of India. By a circular issued under such rules, Government of India has ordered that the no concession can be offered in favor of any member of the defense forces for the purpose of offering prayers during the office hours. In a pity that the fundamentalist Muslim organization named All India Muslim Forum has raised the objection against the circulars articulated by Muslim members in parliament that the various grounds, none of these grounds are however tenable in view of express provision in Article 33 Constitution of India, which silences the argument that the no such restrictions was imposed in the respect of Muslim during the British regime and also would hurt the sentiments of the Muslim, nor does the argument that the withdrawal of such concession would be contrary to the guarantee of secularism hold water because firstly Article 25(1) make it expressly subject to other provision of the part in which Article 33 includes secondly and the Article 25 guarantees is equality of treatment as among different religion. If so much concession exists in favor of the member of any other religion, no question of discrimination against Muslim can possibly arise. Above all, the defense of nation is a secular duty of each citizen of India, regardless of the religious belief or rights. Nothing can be allowed by the independent republic which can possibly jeopardize the defense of the nation. A similar instance was the claim of a section of Muslims is postponed the election fixed on January 1995 on the ground of Ramzan. This has of course been turned down by the election commission on the ground that no such religion plea can stop the electoral process. It is also doubtful if there is a religious scriptures which require Muslims to suspend their normal duties on the days of fasting, which spread over 1 month. When martial law has been enforced in this area, Parliament may, by law, indemnify any person in services of union or state for any act done by him consistent with the maintenance of restoration order in such area of validated any sentence passed or any act done by martial law was in force. Article 34. Suspension of fundamental rights during the proclamation of emergency. The fundamental rights guaranteed by the Constitution will remain suspended while a proclamation of emergency is made by the President under Article 352C. The effect such the proclamation in the behalf of twofold. As soon as proclamation is emergency is made, the state shall be freed from the limitation imposed by the Article 19. This means that the legislature shall be competent to make by any law and the executive shall be at liberty to make any action even though it contravenes of restrictions the right of freedom of speech and expression, assembly, association, movement, residence, corporation, or occupation. So far as these rights are concerned, the citizen shall thus have no protection against the executive or legislative authority during the operation of the proclamation of emergency. The enlargement of the power of the state under Article 358 will continue only so long as the proclamation itself remain in operation. Article 19 will revive as soon as proclamation expires, but the citizen shall have no remedy for act done against him during the period of proclamation in violation of the above right, Article 358. The other consequences depend upon the issue of further order by the President where a proclamation of emergency is operational. operation, the President may by order declare that the right of move to court for enforcement of any of the fundamental rights shall remain suspended for the period of during which the proclamation remain in force. Article 359. In such cases, however, the right to move the court would be revived after the proclamation ceased with force or earlier. It is specified by President order. In such words, in such order issued, Supreme Court and High Court will be powerless to issue the prerogative writs or to make the order of enforcement any fundamental rights, including those which are conferred article other than Article 19, exception of this conferred Article 20 and 21. Thank you.